say, okay, because so Laura and Eva, how can couples avoid the situation where they come to an agreement and only to be set aside later by the courts? Eva, do you want to start?
So there should be a lot of things in place to avoid having a contract set aside. Like I mentioned before, there should be financial disclosure. You do want to make sure both parties understand that agreement. And you want to make sure that if there is a power imbalance, or there were elements, for example, of domestic violence, that you are working with professionals. A kitchen sink deal isn't going to cut it in those circumstances.
Now, Laura, what about you? Do you have any tips? Sort of, how would you avoid this from happening? Maybe.
I completely agree with Eva to have some form of a formal process, but you also have to have. I think of a collaborative process or mediation process, almost like a translator between the parties, because we oftentimes see parties at different levels of understanding in terms of financial sophistication or parenting or communication or things that may hinder the capacity to enter into an agreement, and therefore subsequently may make them regret that agreement because they feel that at this moment in time or at that moment in time they were not on equal playing field. One understood financials really well, one didn't understand it at all, and the mediator or the collaborative space didn't bring them to the same level for that person who did not understand to understand as well, in terms of what we always say, what they're saying yes or no to. So I think it's important to balance that and then that they feel balanced, so they feel like their voices are heard, right? Their concerns are addressed, and if there is a power imbalance, is managed appropriately, such as what Eva had mentioned earlier. If somebody needs spousal support and signs off on an agreement just because needs spousal support to leave the house, that's not necessarily the way that you want to enter a spousal support agreement, right? So that if that's brought up into a mediation context, that has to be addressed accordingly, right? So there have to be some safety pins put in place. So working with a professional is safe. As much as families think that may increase their cost, it's really decreasing their cost, and it's emotionally and financially long term. And it also preserves, it helps create an agreement that stands the test of time, which didn't happen in this particular situation because they didn't have all these elements in place, right? I mean, obviously one of them did not feel heard, or did not express it at that time, regretted it later, and now started a different process. Now that should have been addressed at the onset, right? If there was an itch at that time that needed to be scratched, it should have been scratched at that time to make sure that if it's not 5,000 but it's not 90,000, can it be somewhere in the middle that is going to save the grief and the stress that now subsequently has accumulated for both of them.
I agree. I was surprised in the sense that I have a feeling that if the Andersons had come to a mediation where they were Mr. Anderson, I guess, was educated about he might have said, wait a second here, what am I signing away? Like it would have maybe encouraged them to come to a more balanced agreement, I guess. And they probably would be they would both be better off and just not have gone to court altogether. At the end of the day, I felt the reason why I feel surprised by the court's decision, because I felt that Mr. Anderson did not know what he was signing away.
So it's very nuanced. He knew he was signing without going to a lawyer to figure out what he was entitled to. So he entered the contract with the intention to say, I just want a clean break and I want to move on. And essentially the court kind of took it as like, he didn't care.
Yeah, got it.
Okay. Yeah, and you're right though, Heather. In mediation, we would have told him what he was entitled to right off the bat. Yeah. We would have made sure he knew that. Yeah. What he was entitled to, because really that safeguards someone coming back a couple years later and saying, I think this deal was unfair because I didn't know. That's what he's saying, right? I didn't have legal advice. If I had legal advice, I would have known that I was entitled to $85,000 more and would have asked for it.
Yeah.
That's what he's saying, right?
Yeah.
By saying I didn't have legal advice. So in the mediation process, we would have said, well, do you know what your legal rights are? We would have made sure you got legal advice. They didn't want to go through that procedure at the time. And the court said, we want to respect the autonomy of that.
Right.
You know, which is important too, because you can't, oftentimes Laura and I work with people who are very obstinate in the sense that they really do not want to go to a lawyer. They're very scared. They do not believe in lawyers. They don't believe they're going to have any value added. And in some ways I can understand that, right?
Yes.
But then if you're going to make that decision, you kind of have to live with it.
I think that is
it's a little bit of what this court is saying.
Exactly.
Here,
yeah.
right?
Yeah, that's right. So this is a really good takeaway from this case, is that if you choose not to get independent legal advice, it's your call, and we're going to respect that. You know, not the fact that you regret it a year later.
Right. You can't. Eva says it all the time. You can't use it as a sword later down.
Right.
You can't choose not to have it, but then have it later because now you want a different deal. You know, a year after.
And I think that one thing to point out to our viewers as well is in mediation is not only, you know, you're going to tell Mr. Anderson, whoever it is, you're not going to just tell one spouse what the law is. You're going to be very open and tell both spouses. Both of them should know what the law entitles the parties to. I just want to ask you guys to clarify the term family property, because I know that, you know, with my when I'm reading this case from sort of like a layman's perspective, and I'm reading it in English, right, and I'm just translating everything into common everyday English. So when I looked at the term family property, I kind of thought of that like, oh, is that only referring to things that are owned by both parties, or is that going to be a property that's bought, like a high chair, silverware, whatever, or does it include also my bank accounts, or which is under my name, like? So I was wondering, you guys could clarify that a little bit. Family property, what does that mean?
Yes, and oftentimes I find that, you know, these terms should be clarified in layman terms for everyone, because I feel I think the process would be easier and clearer for everybody. So property, when we refer to the property, it encompasses not just, you know, chairs and homes and real property, but it encompasses, you know, anything like investments, savings accounts, pensions, debts, right, mortgages, or everything that is under that umbrella is considered property. So when we're talking about division,
but these bank accounts, investments, so on, is it just the stuff in joint names?
So regardless of whose name, if you are legally married, regardless of whose name these assets and debts are in, they all go into the family pot, essentially. They all go into the same pot, and they're equalized. So for the exercise of equalization, they're in the same pot and equalized in the bottom line. But yes, regardless of, and that's a very good question, because oftentimes families come to us and say, well, I'm not worried about that because that's everything in my name. Right. And then I don't have to split this RSP, or my pension is my pension. How can, you know, he or she have access to it? And why should he or she, they didn't work for it, right?
That's
or they didn't accumulate it. So no, the property, it has everything in, regardless of, and so some of them have a little bit of a surprise. But that's when the communication and the clarification of these terms is absolutely crucial, because that's when you can make an informed decision, and that's when you're going to have, you know, that hopefully lessen the risk of anyone coming back and saying, I did not know, because these terms were very foreign terms to me, right? We don't use the word property in our day-to-day life referring to you know, pensions, right? I don't say my property is my pension or my investment or my RSP or our joint ones, right?
Yeah.
We use it very differently when we talk about property for family law versus your day-to-day. So
Exactly.
these have to be clarified, and sometimes that's why someone has some regrets, because they're conceptualizing very differently the way that they're going to accumulate property and divide property when there's a separation versus what the law is instructing us to do.
That's great. Yeah, I know, like family law terminology, even though it sounds like common English, it actually means something else. And you're absolutely, Laura, I absolutely 100% agree. I think that if people were educated, like in a neutral environment like mediation, then they can learn about these things. And it's not like you're not a salesman, right? Trying to favor one party or another. Basically, you are there for both of them. You're there as a neutral party, and it's a much better way to receive information and being educated than from, say, opposing counsel or whatever. Because if opposing counsel says something to you, you're like, I don't really trust them. Why would I believe what they say? So I think this is really important. And